Welcome to our second session on the social as the sacred and the realm of sacred normativity, as we called it. We will hear one paper first and then have the lunch break, because our first speaker will have to catch a train to Brussels afterwards during lunch break, unfortunately. My name is Daniel Witte. I'm a scientific coordinator here. Unfortunately, Professor Richard Münch is not here today to chair this session because of a conflicting appointment, but I'm sure as a member of our scientific board he will be here with us in spirit and watch this session. Okay, our first speaker is Laurent de Sutter, which I will present to you first. Laurent de Sutter holds Masters in Law and Legal Theory and a DEA in Legal Sociology from the University Paris 2 and a PhD in Law from the University of Brussels. Among the various stations in his career, I would like to mention several full-time postdoctoral research stipends he received both from the University of Brussels and the Flemish community. He was a visiting honorary research scholar at the Cardozo School of Law and is since 2014 professor of legal theory at the University of Brussels. This impressive career he was able to crown with a fellowship at the Käte Hamburger Center for Advanced Study, Law as Culture, which unfortunately ended in September, and during which he worked on a book called Poetics of Police. And if I got that right, from Sunday on he will be a research fellow at the Waseda Institute for Advanced Study in Japan. Laurent de Sutter is, if I may say so, some kind of an enfant terrible of legal theory, who has interests at the interests in the crossing section of legal theory, political sociology, and political theory and legal history. And I would like to call him an enfant terrible because he's never afraid to touch on topics such as pornography, prostitution, or popular culture in order to illuminate the logics and the even obscenities of the law. He has done so in a number of publications. He has written almost 10 monographs on his own, from which I would also only mention one on Deleuze, Les Pratiques du Droit, an edited volume on Zizek and law, and his latest book on Magic, une métaphysique du lien. So it's not maybe a pure coincidence that he will touch the issue of magic in law later in his talk as well. He has also been managing editor of various series. Among those are the Perspective Critique with Presse Universitaire de France, and he's also managing editor of the Theory Redux book series with Polity Press, and is publishing authors such as Slavoj Žižek, Lyotard, Jacques Rancière, among many others. So with this, the floor is yours, Laurent. Welcome back to the center. We're very glad to have you back, and we'll listen to your talk on Durkheimian mysteries, law, magic, and the sacred in Paul Huvelin and Marcel Mauss. Thank you.
Thank you. Whoa. Thank you. It's good to be back. Despite these most favorable, nice, and flattering words, I'm going to disappoint you, I'm afraid, because of several reasons that I would expose after. First, I thank again Professor Gebhardt for his kind invitation to come and visit the shores of Riverine once more. I'm very pleased and honored to be among such a erudite, famous and brilliant crowd of scholars. And I would like to, of course, to thank the entire staff here at the Käte Hamburger Colleg for making this easy and pleasurable, and especially, of course, Katja Spranz. I said that I would most probably disappoint you because I'm not at all a Durkheim scholar. So my knowledge of Durkheim is really, graduate student level. So I'm very easy to trash on that. I'm not at all erudite and powerful historian such as Jean-Louis Halpérin. So here the landscape or the characters I will feature are characters that will feature for reasons that are not so much historical or even sociological, but are there to try to help me in telling a story about, let's say, let's put it that way, it's much, almost megalomaniac and stupid to say so, but let's say about what law is. Last warning that I have to formulate is the fact that, as you can hear, I'm not exactly in the best shape. So you will have to cope with that too. So I'm going to try to investigate this link between law, magic, and sacred, featuring one particular character that has been mentioned by Jean-Louis Halpérin and Roger Cotterrell a little bit earlier on, namely Paul Huvelin, a lawyer who was part of the editorial team of L'Année Sociologique, so of Durkheim's vehicle, so to speak, and who actually published a small handful of very weird, very strange, very curious publications that nowadays are not read by lawyers anymore for reasons that pertain, I suppose, to the history of legal history in France in the second half of the 20th century. Despite the fact that they present very interesting and very powerful insights about the origin of law and about the origin of a certain amount of institutions, mainly Roman institutions, that can tell us something, or at least is a claim that I will formulate, about law per se. So the question that is behind this intersection between law, magic, and the sacred, or the entry point that we'll pick, is a question of the obligation, of the status of the obligation. What is an obligation from the point of view of law? And while asking what is an obligation, of course, I do not intend to fully develop a theory of obligation. I simply intend to point out in the concept of obligation, the idea of obligation, the institution of obligation, the invention and the transformation of the institution of obligation throughout time. One specific point, which has, as a matter of fact, been touched upon by Professor Turner, which is the question of necessity. Why is it so that we are obliged by an obligation? Why is it so that an obligation has necessary effect? Or is it so that an obligation has necessary effect? What kind of a necessity is it that is linked with the idea of an obligation? And in order to understand this necessity, the tool that I will use is the tool of magic, as it was used at a certain point in time, namely at the end of the 19th century, in order to try to answer the question of the necessity precisely as attached to the idea of obligation. What was the situation? The situation is well known. I mean, it's the introduction of Mauss and Huber, Esquisse d'une théorie générale de la magie, this memoir published in 1902 in L'Année Sociology precisely, where they're trying to cope with the idea of magic as they have seen it being exerted or having received an explanatory power in anthropological circles at the time. The studies, famous studies of anthropologists, from Codrington to Fraser, the English school of anthropology has had an important recourse to the category of magic in order to explain a certain amount of social phenomenon and of social, let's say, situations, such as ritual situation and so on and so forth. So they enter into the arena trying to define what magic is while observing these rituals that it could, about which they had material at hand. And they give this definition of magic. And they say, magic is tout rite qui ne fait pas partie d'un culte organisé. Every rite or ritual that is not part of an organized cult. So what does that mean? I mean, it's a definition of magic that is obviously very different than the spontaneous one that we can have. You know, magic has been spells, maledictions, I don't know, filters, whatever you can think of. Here, it's something that is directly linked to some kind of a social situation and a certain amount of, let's say, staging of a social situation where a certain amount of words and of gesture will be, let's say, theatralized, but that are not part of an organized cult, so that are not part of religion, to put it that way. So magic is the rite of the ritual that will distinguish itself from the religious ritual. What is the final outcome of magic? What will characterize magic as opposed to religious cult is, that's what they say, the belief in the absolute, limitless efficacy of direct creation. That's what they say. Absolute, limitless efficacy of direct creation. There's magic when there is a ritual outside of religion that produces a direct effect, and of which the directness of this effect is part of the ritual itself. Okay, it's the ritual itself that possesses, so to speak, the power to produce consequences that are necessary. But, and that's the important part, they point out that it's about belief. So they point out the fact that this efficacy of direct creation points toward what they say is some sort of an ideology. So it's a certain community that believes in this power of creating directly things that defines magic. And they add another quotation here: rituals are essentially capable of producing other things than conventions. They are eminently, well, efficace, I don't know if it has any meaning in English, you know, they would say efficace in French, but not instead of efficient. No.
Efficacious.
Efficacious, okay, so it's efficacious. They are creators, they make. So first thing, to distinguish magical ritual from religious cult. But that's not the end of the distinction they make, and that really frames or framed the debate. They had that this magic ritual distinguished themselves from legal, juristic actions or legal juristic rights. They say as far as they manifest a specific efficacy, as far as they do more than establishing contractual relationships between beings, they are not juridical but magical or religious. So the question of the efficacy, the question of the efficacious character of gesture and words should be refused to any kind of juridical action or any kind of juridical convention as opposed to magic. Is juridical what is ritual without being efficacious. Okay? Which is, I imagine, for sociology something a bit bizarre. For a lawyer, it's even more bizarre to consider that what is juridical is not efficacious and would distinguish itself from magic from that very point of view, that it would not have some direct action. Or if it's the case, then we have a big problem about what law is, because if there's a case, it means that something is efficacious on behalf of law, which means, by way of consequences, that law per se is nothing but the efficacy of another agency that would supersede it and then cover it completely. It's an intuition. This problem was already intuited by one of Marcel Mauss' disciples, namely Georges Gurvitch, who, as you know, wrote the first preface to well, the preface to the first edition of Anthropology and Sociology in 1950, where the esquisse d'une théorie générale de la magie was republished. And earlier on, Georges Gurvitch expressed some doubt in an article, a big article that became later a book, called La magie et le droit, an article of 1939, so more than 30 years after Mauss and Hubert Mémoire. Some kind of an implicit critique to this clear-cut distinction formulated by Mauss, by saying that if we want to interest oneself into law, and if we want to interest oneself, or if we want to have a look at magic, it's not the separation between law and magic that we have to look for. We have to look for, and I quote, the intermingling of the magical relationship with the juridical relationship in the obligation. So it is through the lens of the obligation that it's possible to see that the clear-cut distinction between magic and law is something that is at least, or hypothetically, problematic. And what he wants to do, and I would like to also explore in the rest of this talk, is precisely what we can say about this possible intermingling, despite Mauss and Hubert's claim that what is juridical is what is not efficacious. And in order to understand that, I would like to come back to a very old, the oldest form of obligation that we have at hand. A form of obligation that is already described, although in very obscure terms, in the 5th century before the present era in the Law of the 12 Tables. With this dictum, or with this, it's not an article, with this formula that you can find on the Law of the 12 Tables, that says, cum nexum facet mancipiumque uti lingua non copacit itaius esto. He, not she, he who performs a nexum or a mancipatio and pronounces the words, may he dispose of a right. So the nexum, for those of you who don't know what it is the first type of, let's say, a guarantee that we know of in Roman law. I may be wrong on that, but to my knowledge, it's the first one that we know. So it's a form of, per eis et librum kind of institution. So it's a situation where, in order to guarantee the fact that you are going to pay the money you owe to your creditor, you will put yourself into the situation where, if you don't pay, you will be taken as a slave, to put it that way, until the moment when your debt is erased. In order for this institution to really happen and to really produce its effect, of course, a certain amount of gesture and formulas, gestures and words have to be put forth. The gestures that are called per eis et librum, so with bronze, and very complicated, and maybe Jean-Louis Halpérin can enlighten me on that. It's very complicated to know what exactly per eis et librum means. According to some historians, it has something to do with a certain weight, but to others, it has to do with a certain type of object. But what is commonly assumed is that the one who is actually pronouncing the words of the parole or the formula of the nexum has to hold, or must be in the presence, that's also an obscure point, of someone who will hold a certain mass, a certain amount of bronze, in the hands, both hands, eis on one side, librum on the other, and then pronounce a formula of which we don't have the wording, but a formula that we know was called a formula of damnatio, a formula of damnation. And by acting that way, by pronouncing the words, then the debtor would be considered as being susceptible to be taken as a slave if he would not reimburse his debt. It's considered as a first step towards the development, progressive development in Roman law of the idea of obligation. And here, as you can see, or there's something I forgot to say, here, what is particular about that is that, you know, the type of procedure that you will follow if ever the debtor doesn't pay what he has to, is called manus injectio, which means to put in hand. So there's the idea of directly grasping the body to put it in the situation, the new situation that has been caused by the fact that he has not fulfilled his obligation. But in order for a true obligation to appear, one had to, or historically at least, one had to get rid of the direct manipulation of the body and to try to invent a form of necessity that would not imply directly taking hostage of a body and bringing it with you. So it's a process that I will, I jump on the stage. It's quite complicated, and there are several steps in the development of that. But as I said, one of the most important here is the invention or the creation or the conceptualization by Publius Mucius Scaevola during the 2nd century before the present era of the distinction between the real effect of a convention and the obligatory effect of a convention. When you have manus injectio, when you put your hand and then you bring a person, the effect, so to speak, can be considered somehow as an effect that has something real to it. Real effect normally is based on, it's goods arrests, a thing that will pass from one hand to another, right? What Publius Mucius Scaevola says is that it's possible to assume that despite the fact that most convention will lead to an actual transmission of a physical good from one hand to another, there are also cases where actually the good will not move. For instance, let's say a building, a construction, you will not take it and bring it with you. And the fact that you will not take it does not imply the fact that you will not benefit from a new situation. And that would be, according to him, what he called the obligatory effect. So this opposition between the physical necessity of an obligation on the one hand and what we can call the metaphysical necessity of an obligation on the other hand. This development of a metaphysical necessity attached to the obligation is something that has puzzled legal historians and that has puzzled specialists of earlier form of Roman law, trying to define, okay, what does that mean, this type of obligatory effect? So the fact that there is something happening, but this something happening doesn't change a bit about the physical organization of the world, but nevertheless, it produces effect. How can we call it? How can we characterize it? And in the 1930s, so a little bit at the same time as George Gurvitch, at the moment when Gurvitch was writing his piece on magic and law, another specialist in an article on these two institutions that were designated, the law of the 12th table in the excerpt that I just mentioned, so Nexum on the one hand, Mancipatio on the other, Henri Lévy-Bruhl directly used the term magic also to try to grasp, at least verbally or at least conceptually, this explanandum, the possible explanandum of the obligatory effect of a convention. Going back to this possible link between law and magic that Mauss and Hubert had so hastily discarded. And Gurvitch himself, coming back on the institution of, quoting, let's say, Lévy-Bruhl, in this piece on magic and law, Gurvitch himself wanted to, or pretended to try to understand what he called the influence of magic on the very spirit of law. And he adds, on the idea of justice that inspires it, on the form of link or bond that it establishes between subjects on one hand, between subjects and objects on the other. And while wanted to understand this influence of magic, this intermingling I mentioned earlier on, he went on to mention and to describe lots of scholars, but he insists particularly on one, the one I announced, namely Paul Huvelin, and he quotes two pieces from Paul Huvelin. A piece from 1900, when Huvelin was only 27, called Les Tablettes Magiques et le Droit Romain, so a study on the tabulae de fictionis, which are also kind of cursing method. And in 1906, so after Mauss and Huber, La magie et le droit individuel, magic and individual rights. And in the second piece, La magie et le droit individuel, the one I'm going to speak the most, he has two questions. He says that he wants to answer two questions. First question, the rights of an individual or subjects, are they rights with which magic has originally shared its power? So is there a relationship between the power of magic and the power of rights? And second, what are the features of these rights and how do they distinguish themselves from those that don't show any kind of magical imprint or influence? So it distinguishes two types, let's say, of rights. Rights that originate or that have some kind of relationship with magic, and rights that don't. I will not, of course, go into the whole list of instances that is trying to analyze. It's really some kind of an overview, of cases to say here we can have hints at the fact that maybe there's some magical intervention of that sort, and here another, and so on and so forth. I would simply jump to something that is more conclusive or more general, meaning that here the rights of the individual that he's looking for mostly, firstly, concern what he calls individual property. Says les rites magiques, magical rituals, have given to individual property its first sanction. So it was, let's say, at the very origin of law, so to speak, at the very origin of property, the possibility that property would be enforced and that property could be something individual as opposed to collective property passes by the intervention of magic. The jump from individual property the jump to individual property, so to individual rights, is a jump that is permitted, rendered possible by the intervention of magic or magical rituals. Il says, en prêtant à l'activité individuelle sa force propre, la magie a préparé la voie aux sanctions juridiques. Elle a fait entrer l'activité individuelle dans le droit. This side of, from the individual from the collective or to the pre-individual, let's say to the individual, is of course something very important, very striking. He also adds, as a definition of magic, because it's very blurred here, we don't know magical ritual, okay, which ones, which circumstances, how, so on and so forth. So he tries to go a little bit further and to try to explain what he means by magic with a reference that hints somehow at what Mauss and Huber said a few years earlier on. It said, dans le domaine du droit, le rite magique n'est qu'un rite religieux détourné de son but social régulier et employé pour réaliser une volonté ou une croyance individuelle. So, again, the difference between the religious and the magic, or the magical, we find it again, although here the difference between magical, religious, and legal has been slightly displaced, right? And the displacement is rendered possible by the fact that the magic ritual is considered by Huvelin, and not by Mauss and Huber, as itself a religious ritual, but détourné de son but social régulier, but who has been, diverted from its normal purpose, that has been perverted, so to speak, from its normal social purpose, in order to favor or to render possible something that is not social, but something that is individual. A will, une volonté, or a belief, une croyance individuelle. And Gurvitch, when he quotes these texts and tries some kind of an overview of these texts, he tries to give a general interpretation of this, hints, very partial hints given by Huvelin in La Magie, or Magie et le droit individuel. And he argues somehow, especially with the case of the Nixon that is mentioned by Huvelin as one of the major cases, or the most important cases in his portraying of the place of magic in archaic or ancient law. Gurvitch says, well, if we look at Nixon, then what we understand is that first, there's magic only if there's power, okay? Magic is the manifestation of the recognition, reconnaissance, I don't know if we have to say recognition or acknowledgement or reconnaissance. It has some kind of Hegelian, overtone. Reconnaissance, recognition of a power exceeding the one of the subject subjected to it. It is the manifestation of the recognition by a subject of the impossibility to ignore it. You recognize the fact that you will not ignore it. It's kind of circle. That is, magic is the manifestation of the recognition of the individual right of a subject, such as the right of the creditor to whom damnatio precisely provides existence, in return. When the formula is pronounced, suddenly you exist as the creditor of the debt. So there's power, not power in terms of power structure, Foucauldian power, whatever. No, there's power in terms of there's something acting, there's something operating. So that we can conclude with Gurvitch that if magic is anything, then it should be described as an operation. That's something that allows to operate between different categories or different fields. The operation being here the operation of necessity. I will have to go a little bit further about that, the operation of necessity. What does it mean? What it is? But first, let me say that this view of... Oh, sorry, I'm going to do something not very stylish, sorry. Thank you. So the problem is that it happened that this link between law, magic, religion in Roman law, despite the fact that it went quite far in history, and despite the fact that it sparkled interest from anthropologists, sociologists, and then lawyers at the end of the 19th century, at the beginning of the 20th century, doesn't have to make you forget that obviously the history of obligation is a history that has tried to avoid completely the fact that an obligation could produce effect per se, could produce effect per itself, could produce some kind of effect by the exercise of magic as the operation of necessity. Lawyers in the history of obligation, especially in the modernity, have always tried to find another explanation than magic. Another explanation that would add something to law, that would justify this necessity that seemed to be, if one hear Huvelin, if one hear Gurvitch, if one looks at the early form of obligation, seems to be self-sufficient. You say the words of the nexum, you proceed to the gesture, and then something changes. Something changed that makes you the holder of the right, and that puts you in a situation where you were not before. And the necessity is, of course, the necessity of this change. Well, for lots of lawyers, this is something that's problematic in the history of obligations. And instead of looking at the possibility that an obligation can put forth direct effects, would join Mauss and Hubert in the belief that another instance is at work, be it like it was the case for Jean Domas, of whom we were speaking during this morning, being the figure of the law itself, the law with the big L, that goes back or goes up to God as the supreme guarantor of any obligation, so to speak. And you can find this in Doma. It's quite striking to see that God pops here and there when it really matters. We need someone to guarantee things. So, when we look at Potier, or it's the same. So the figure of the law per se, something which is quite complicated to say in English, by the way. The law as opposed to law, you know what I mean? Or whether it is, as it was the case in 19th century German jurisprudence, let's think of Fabiani, of course, of something that would look on the side of the social, whatever social means here, The problem with that is that, of course, if you consider that in order for an obligation to have effects, you need either God, or you need police, or you need a government, or you need a state, or you need a society, and so on and so forth. Then, at least from an hypothetical point of view, the obligation per se doesn't matter. I mean, you can do whatever, provided that there's an institution somewhere external that will guarantee it. And the intuition that one might have looking at this earlier form is that was there really an institution to guarantee the thing? Or isn't there a confusion between two levels of consequences to be expected from the obligation? Isn't there a confusion between the fact that an obligation produces, let's say, legal effect, and the fact that if these legal effects are somehow rendered impossible to have consequences, then something will happen, and then police will enter into the picture and will chase you. I mean, you don't pay your debt, you are in the situation where you could be taken as a slave. The same as the creditor with a guarantee becomes something different than it was before, and this effect is something that happens with the obligation. Now you can run and avoid the consequences attached to this obligation, and then the police will maybe chase you and maybe catch you and maybe not. But there's a difference, or here's something which is that should be clearly discussed or clearly made, or we're mixing different things together. We're mixing the social consequences of an obligation and the legal consequences of the obligation itself. And this is something that has preoccupied Roman jurisconsult, such as Scaevola mentioned, with this distinction between real and obligatory effect. But it has puzzled and interested other commentators of the history of obligation also. And especially and I'm again speaking under the authority of Jean-Louis Halpérin, who knows that much better than I do, that in Middle Ages, and up to, let's say, 13th century, the discussion on the distinction you have to make between real obligatory effect, between what is an obligation, what is a convention, what is a pact, what is the effect of a convention or the obligatory, all this distinction that lawyers are expert of making, this sibylline, apparently obscure and meaningless distinction. Well, there has been, lots of discussion and controversy, to try to really understand what was at stake. As such, the obligation as such, without having to make another thing, another instance into the picture. And you remember maybe in Justinian's Institutes, the definition of what an obligation is, it says that obligatio, obligation, is juris vinculum, is legal bond that necessarily uses, in the institute you find the word necessarily, necessitate, as stringimua liquius solvanda rei, so necessarily constrains the one who is in debt, secundum nostrae civitatis jura, according to the rules of our city. So this idea of juris vinculum that lawyers continue to use these days is something that is put for Justinian as some kind of an equation. So we have real effect, scaevola, obligatory effect, the obligation being the effect of a convention, and according to Justinian, there is some kind of equation here between obligatio, the obligation as the effect of a convention, and the vinculum juris. It's the same. But in the debates goes on and on and on and on. And when you arrive at the 13th century, and when you meet this figure of the post-crusader Jacques de Revigny, you know that he's a little bit upset about the fact that the preceding scholars have always tried to create this equation, to explore this equation, obligatio est juris vinculum, the obligation is the legal bond, by some kind of analogy. The fact that the juris vinculum, the legal bond, should be considered as if it was a physical bond, you know, and they compare it as the bond with which you hold, you know, your a beast or something like that, you know. And it says we have to distinguish between the vinculum juris and the obligatio, and it says we have to distinguish between the operation and its consequences. So we are in a situation here where we are three different instances. So we have the convention itself, we have the operation inside of the convention, namely the vinculum juris, and then you have the consequences, the necessary consequence from the functioning of the operation inside of the convention, and this is the obligatio. And the obligatio is the necessary consequence of the conclusion of a vinculum juris through a convention, being a dispositive allowing to decide on a vinculum juris. A moment of necessity. A moment of necessity that you cannot avoid, a moment that is absolutely necessary, whatever the contingent coordinates of the actual convention are. That's what is fascinating. And this moment of necessity in the middle of total contingency is what we could maybe describe here as precisely a moment of magic. A moment of magic, the moment of magic of the creation of a legal bond that will then put this operation, the operation of the vinculum juris, into a chain of legal operation. One legal operation leading through its consequences to other legal operation, and so on and so forth. You steal, or you marry. The fact that you marry then makes so that, it's not a convention here, of course, but the fact that you marry leads to consequences from the point of view of filiation. Filiation leads to consequences from the point of view of heritage, and so on and so forth. So we enter through this figure here of the nextiment, the figure of the obligatory effect, into some kind of a realm of operation leading one to the other in some kind of an endless, you know, flow of legal consequences, without having to recourse to an external instance, except of course for the contingent consequences that could be the byproduct of this chain of legal consequences. And it's quite funny, and maybe that will be my conclusion here, to consider that this idea of a magical moment, a moment of necessity, based on the idea of operation, actually originated in the study by lawyers and social scholars belonging to the group of Durkheim at the beginning of the 20th century. It's quite funny because, of course, it leads us into a legal landscape where what is at stake is an endless network, an endless tissue of operational links leading one to another, rather than this figure to which Durkheim has been most associated with, especially in France, so namely the figure of the lien social, the social bond, figure general, some kind of a general and abstract figure, as general and abstract as law is considered usually. Whereas if we look at law from the magical perspective, there is of course nothing more than practical and concrete through, of course, the production of this necessity. Thank you very much.